Hello and welcome to MD's Law channel. In this video, we are diving into part 4 of our detailed AIBE 17 paper explanation series. 31st question is: if the factory employs more than 1,000 workers, they should appoint qualified to carry out the prescribed duties. The correct option is A, Safety Officer. According to Section 40B of the Factories Act, 1948. 1. Advise and assist the factory management in the fulfillment of its obligations, statutory or otherwise, concerning the prevention of personal injuries and maintaining a safe working environment. 2. Inspect the plant and equipment for safety and identify hazards. 3. Investigate accidents and incidents to find causes and preventive measures. 4. Develop safety programs and policies for workers and ensure their implementation. 5. Organize training sessions and educational programs on safety. 6. Prepare safety manuals, safety reports, and other documentation as required. 7. Advise on safety-related purchases of equipment and materials. 8. Ensure compliance with safety regulations and laws. 32nd question is: B. The proprietor of a newspaper publishes at A's request a libel upon C in the paper, and A agrees to indemnify B against the consequences of the publication, and all costs and damages of any action in respect thereof. B is sued by C and has to pay damages, and also incurs expenses. Decide in the light of the Section 224 of the Indian Contract Act, 1872. The correct answer is A. A is not liable to B upon indemnity. According to Section 224 of the Indian Contract Act, 1872, where one person employs another to do an act which is criminal, the employer is not liable to the agent, either upon an express or an implied promise, to indemnify him against the consequences of that act. In this case, publishing a libel upon C is a criminal act, and A employed B to do it. Therefore, A is not liable to indemnify B against the damages and expenses that B had to pay to C. This question is nothing but illustration B of Section 224 of ICA 1872. 33rd question is: a person whom the agent names to act for the principal in the business of agency, under the express or implied authority to name, is called. The correct answer is B, substituted agent. Sub-agent. A sub-agent is appointed by an agent and works under the agent's authority, not directly for the principal. Substituted agent. A substituted agent is appointed by an agent, with the authority from the principal, to act for the principal in the business of the agency. This appointment can be either express or implied. Agent. An agent is a person who acts on behalf of the principal. In the given context, the term substituted agent refers to someone appointed by an agent, with the principal's authority, to carry out the business of the agency on behalf of the principal. 34th question is: a injunction can only be granted by the decree made at the hearing and upon the merits of the suit. The defendant is thereby perpetually enjoined from the assertion of a right, or from the commission of an act, which could be contrary to the rights of the plaintiff. The correct answer is B, perpetual. Perpetual injunction, granted by a final decree at the hearing of the suit, permanently restrains the defendant from doing an act that infringes the plaintiff's rights. Temporary injunction, granted for a limited period, often until the case is resolved. Intended to maintain the status quo until the final decision is made. Thus, a perpetual injunction is the correct term for an injunction granted by the final decree, preventing the defendant from violating the plaintiff's rights permanently. 35th question. According to Section 5 of Specific Relief Act, 1963, a person entitled to the possession of specific immovable property may recover it in the manner provided in dash. The correct answer is B, the Code of Civil Procedure, 1908. According to Section 5 of the Specific Relief Act, 1963, a person entitled to the possession of specific immovable property may recover it in the manner provided by the Code of Civil Procedure, 1908. This means that the process for recovering possession of specific immovable property is governed by the procedures set out in the Code of Civil Procedure, 1908. The Specific Relief Act itself does not provide the detailed procedural framework for such recovery. Instead, it refers to the established procedures in the Code of Civil Procedure. 36th question is, where the mortgagor delivers possession of the mortgaged property to the mortgagee, and authorizes him to retain such possession until payment of the mortgage money, and to receive the rents and profits accruing from the property in lieu of interest, or in payment of the mortgage money, the transaction is called an dash mortgage. The correct option is D, usufructuary. A usufructuary mortgage is defined under Section 58(d) of the Transfer of Property Act, 1882. A usufructuary mortgage is a type of mortgage where the mortgagor delivers possession of the mortgaged property to the mortgagee and authorizes him to retain such possession until payment of the mortgage money, and to receive the rents and profits accruing from the property in lieu of interest, or in payment of the mortgage money. This is one of the 6 types of mortgages recognized by the Transfer of Property Act, 1882. 37th question is, Mr. Manjot is a trader supplying goods from his M.S. Singh Traders. The office of the firm is located in Delhi, whereas its god-owns are located in the state of Uttar Pradesh, Punjab and Jammu and Kashmir respectively. M.S. Singh Traders made following intra-state supplies from different states during the current financial year. I. Delhi taxable supplies, 21 lakh rupees. E. Punjab exempted supplies, 6 lakh rupees. E. Uttar Pradesh taxable and exempted supplies 3 lakh rupees each respectively. IV. Jammu and Kashmir taxable and exempted supplies, 8 lakh rupees and 3 lakh rupees respectively. The correct option is B, Delhi, Uttar Pradesh and Jammu and Kashmir. Mr. Manjot is required to take registration under GST in the states where he makes taxable supplies of goods exceeding the threshold limit. Mr. Manjot only makes exempted supplies from Punjab, which are not liable for GST registration. Therefore, he does not need to register in Punjab. Similarly, he does not need to register in the state where his godowns are located, unless he makes taxable supplies from there. Hence, he only needs to register in Delhi, Uttar Pradesh and Jammu and Kashmir, where his taxable supplies exceed the respective threshold limits. 39th question is, which of the following is not a negotiable instrument as defined under the Negotiable Instrument Act, 1881? The correct option is D, bill-in receipt. A bill-in receipt is not a negotiable instrument as defined under the Negotiable Instruments Act, 1881. A negotiable instrument is a written document that contains an unconditional order or promise to pay a certain sum of money to a specified person or to the bearer of the instrument. According to Section 13 of the Act, there are 3 kinds of negotiable instruments: promissory notes, bills of exchange and checks. Promissory note, a written promise to pay a certain sum of money to a specified person or the bearer of the instrument. Section 4 of NI Act. Bill of exchange, an order made by one person to another to pay a certain sum of money to a third person. Section 5 of NI Act. Check, a bill of exchange drawn on a specified banker and payable on demand. Section 6 of NI Act. 40th question is, according to Right to Fair Compensation and Transparency in Land Acquisition Rehabilitation and Resettlement Act, 2013, appropriate government can acquire the land for which of the following purposes? 1. For strategic purposes relating to naval, military, air force, and armed forces of the Union. 2. Project for water harvesting and water conservation structures, sanitation. 3. Project for project-affected families. 4. Project for sports, health care, tourism, transportation or space program. The correct option is D. All are correct. The Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act, 2013, commonly known as the Land Acquisition Act, 2013, specifies the purposes for which land can be acquired by the appropriate government. Since all the given options are valid purposes for land acquisition under the Act. Statement 1. This includes the needs of national defense and security. Statement 2. These projects are aimed at environmental conservation and public health. Statement 3. This involves land acquisition for the resettlement of families affected by previous land acquisition projects. Statement 4. These projects are aimed at public welfare, development of infrastructure, and enhancement of social amenities. We have covered 9 questions in this video. The AIBE previous paper series, we will cover the remaining questions and old papers as well. If you like this explanation, please like the video and share this video to AIBE aspirants and your friends. Do not forget to comment below if you have any doubts in this questions, or if you want any new topic, please mention in comments, and don't forget to subscribe our channel. Thanks for watching. Keep watching for a better understanding of legal concepts. This channel is designed for students and competitive exam aspirants. It's beneficial to solve more and more questions, like the ones we provide in our shorts. See you soon. Bye.